the sentencing range on this case is roughly 9 years all the way up to 22 years in 8 months.
So minimum is 9 years?
Yes, the minimum would be approximately 9 years. Now, the judge could theoretically stay certain allegations and get below that, but that would be pretty unlikely.
Do you feel that's appropriate for the nature of the crime?
You get 9 years.
You know, my job as a deputy district attorney is to enforce the laws as they're written by the legislature, so I don't really make those decisions.
I'm asking you as a human, not an...
So I would say that anytime you point a gun at somebody and pull the trigger 5 times, that's an action that could easily kill a person. I think that's an action that deserves serious consequences.
But that's not necessarily what happened, because Sean Kelly said something totally different. He said the 2 women fought, and then they were outside, one went back into the car to retrieve something, and then there was flashes. So how do you put 5 shots in Tory's hand?
Well, that's based on Megan's testimony, Kelsey's testimony, and Sean's testimony together. So
yeah, but Sean Kelly's testimony changed after he spoke to you. In the transcripts, it says what I just said. He didn't add they were stomping on her and trying to kill her and throw her on the river until he got on the stand. He was originally thought of as Tory's witness, not Megan's.
And the credibility of witnesses is the province of the jury.
That's right.
Like the psychological nature of memory consolidation and how it affects the witness testimony?
I would just add that Sean Kelly also said that he heard 5 shots, and the theory of the case from the outset was that Tory fired the gun 5 times at Megan. That was our theory of the case.
That was your theory, but Megan said it, right?
Jury, and that's the jury ultimately endorsed that theory and voted guilty. I mean, to convict somebody of assault with a semi-automatic firearm, that's what they believed was true, based on the facts that they heard. So
no, I agree.
It's not my
I
place
got you.
to question the judgment of the jury.
Something missing from the post-conviction filings was anything about the jurors. A lot of the times in motions for a new trial, you'll see defense attorneys quote jurors, things like that. Have you heard about whether anyone's had contact?
No. Yeah, one way you can get a motion for a new trial is if a juror says something inappropriate happened, like they flipped a coin and reached a verdict that way.
Yeah, but what about a reporter that's the mouthpiece of the prosecution that lies blatantly that the defendant is screaming in public?
I think the reporters that cover this case are doing a great job. I think
you didn't answer the question. What about reporters that do things that are a lie and they're promoted by BET, which is owned by Viacom, which also has a relationship with Rock Nation? How is that fair journalism, or how are they a real court reporter?
I have nothing but respect for the media that cover this case. I think everybody's doing the best job they can.
That's slick.
Can you explain the enhancements? I know there's like a gun enhancement. Can you explain that? Like there's a 9-year minimum, but on top of that, would there be a gun enhancement stacked on that?
Yeah, so the assault with a semi-automatic firearm carries a sentencing range up to 9 years. But then the jury also found true that the defendant personally used a firearm, which carries a triad of 3, 4, or 10 years. So,
but this is the other weird question. How come? Well, okay, guys, sorry.
Theoretically, on count 1, you can get to 19 years if you got high term on the assault with a semi-automatic firearm, and then high term on the gun allegation. But that would be if you got high term on both.
But how did you prove it was his gun, though?
So for that allegation, you don't have to prove that it was his gun, just that he personally discharged the firearm.
Yeah, but his DNA, but the DNA.
This is the last question we're going to answer.
Yeah.
Can the enhancement...
Based on that, we're going to be leaving.
What? I'm sorry?
Well, he's not a part of
I cannot vote for safety. I cannot disagree.
One consecutive...
Yes, good question. There's discretion in the trial court to run concurrent or consecutive. Yeah, so there's discretion there. Yeah.
Okay. Thank you, everyone.
Yeah, was there anything that you wanted to add, being a person who testified and a witness to the case? Was there anything that...
Yeah, she's speaking to you.
Thank you for answering the question.
Okay, thank you.
Anyway, so for young lawyers, though, to make them understand what's the best way to do their case, they have to have evidence, wouldn't you say? They have to prove a client's innocent, even if you are a defense attorney, correct?
So what the question is...
for young lawyers, wouldn't you say to them, regardless if you're a prosecutor or defense, you have to prove your client's innocence, correct?
No, you never have to prove your client is innocent. You have to prove that the government didn't prove the case beyond a reasonable doubt. So the idea that you have to prove someone's innocent is not factually accurate. You just have to prove that the government didn't meet its burden in proving a case beyond a reasonable doubt. So you can be likely guilty, you can probably be guilty.
But that's what I mean, though.
Yeah.
It has to. You have to prove someone's innocence, though. Like the DNA didn't matter in this case, though.
No, a defense attorney never has to prove their client's innocent. That's incorrect.
Well, I know you say that, but what I'm saying to the public, though, and if someone wanted to beat you in a trial, you'd have to prove what you said is incorrect. No, you have to have object to it or have another. That's what I'm trying to say.
They would have to show that we were not able to prove our case beyond a reasonable doubt.
That's what I said. Thank you.